Welcome to Estate Planning. My name is Rob Morris. I'm the chair of the Stark & Stark Estate and Trust Group. A little bit about our firm before we get into estate planning. Stark & Stark is a full-service law firm. We offer diverse areas of legal practice, everything from personal injury to business and transactions to real estate and commercial litigation. If you have any legal needs in any area, not only estate planning but others, please feel free to reach out to us. Obviously, we're here for estate planning, and I do thank you for joining us today. I'm going to be covering a variety of tax issues that are generally related to estate planning, as well as a few strategies that you could possibly use in your scenario. And again, every situation is different. So if you have any questions concerning your individual estate plan, my phone number is there on the screen. I'm going to read it off, 609-945-7617. That's my direct phone number. Please feel free to reach out to me, and I'd be happy to discuss with you in more detail. Okay, I am not advancing. There we go. So here's the outline for today's seminar. First, we're going to talk about estate planning related topics, and then we're going to run through a few estate planning options and opportunities. Again, everybody's individual circumstances may vary, so I do encourage you to reach out and contact us regarding your estate plan. Now, from a very generalized perspective, everybody should have at least 3 estate planning documents. Those would be a healthcare power of attorney, a power of attorney, and a will. In my opinion, those are documents that everybody should have. They cover a variety of circumstances that we're going to get into in a little bit of detail. And frankly, if you don't have them, you're leaving not only yourself, but also your loved ones exposed if there's an issue. So, for example, if you're disabled and in the hospital and you don't have a healthcare power of attorney, it's going to be an issue as to who can make healthcare decisions and under what circumstances. So it's really important that you have those 3 documents. I also put up on the screen a revocable trust. Revocable trusts aren't for everybody, but they are an important tool that if they're a good fit for you, you should be at least looking into. So those 3 documents, the healthcare power, the power of attorney, and the will are, in my opinion, a mandatory for everybody. And for those people where it fits, a revocable trust should be considered as well. So what are some of the alternatives and repercussions if you don't have the documents in place? Well, number one, during your lifetime, if you're incapacitated, well, New Jersey's got a plan for you, and that's called a guardianship. All right. What a guardianship is one of your family members goes into court and asks the court to take away your rights permanently. And then whoever this family member is, will make decisions for you. All right. So number one, it's an expensive and time-consuming process. And number two, it involves the court system. And it's something that can be easily avoided if you have a power of attorney for healthcare and a power of attorney for financial and legal decisions. Conversely, if you don't have a will, again, New Jersey has a plan for you, and it's called intestacy. All right. And that, again, is also going to involve unnecessary expenses, just like the guardianship. And New Jersey does have an estate plan for you as well, which may result in your estate passing to individuals that you otherwise would probably not want to have your estate plan. So this could all be avoided with a will. It's a relatively straightforward document. Has to be done properly, though. And again, if you don't have these documents in place, you're putting not only your family, but yourself and your assets at considerable risk for waste. All right. So what are some of the lifetime benefits of your estate planning documents? The first one I'll talk about is a power of attorney. So that's a power of attorney that's going to make financial and legal decisions for you. So some of the benefits are, number one, you can designate who your agent is. So if you're married, oftentimes that's going to be your spouse. If you're not married, oftentimes it's a family relative, right? And if you don't trust them, then it's a close friend, right? But the important thing is you get to pick who the agent is. Yeah, and if you don't do this, you're going to go through a guardianship into court, and that's going to be time consuming and expensive. The other thing the power of attorney is going to do is it's going to appoint this person to act relatively quickly. All right, so you can get the power of attorney in place a lot faster than you can do a guardianship. so that that individual agent can start making decisions in your best interest to help you with your affairs if you're unable to do it. So those are some really important lifetime benefits of powers of attorney. Similarly, there's a revocable trust. Now, I guess for some clients, perhaps that are older or that may have management issues, they can appoint a co-trustee on the revocable trust who will assist you in managing your affairs through the revocable trust. And that co-trustee, again, like the power of attorney, can be implemented fairly quickly and avoiding a lot of the expenses that you would otherwise have if you didn't have the documents. So there's some very important lifetime benefits for the estate planning documents. Frankly, for some older folks, I'm just going to mention, we all see the phone calls and the text messages and the emails that are total frauds. We all know they are, but unfortunately, what we see sometimes with some of our older clients is they start responding to those uh, inadvertently, because they don't understand what they're getting into. And if you don't have a power of attorney or a co-trustee in place, a lot of these older clients are on their own, and you're kind of throwing them out there to deal with these people that are sending these scams around, hoping to bait them into responding, and they do, unfortunately. So if these items aren't in place, you may not hear about the problem until well after the fact, and by then it's probably too late. So that's another important thing that we're all facing in today's society. If you feel a family member is at risk for these types of scams, then you really need to be looking into these documents here, not only getting them, but also implementing them. Okay, so let's shift gears. Let's put the documents aside for a little bit, and let's talk about estate and inheritance taxes. And before we get into this discussion, I'm just going to preface it with the following. So Stark and Stark, most of our clients are in one of three states. They're either going to be in New York, Pennsylvania, or New Jersey. So a lot of the estate and inheritance tax information that we're going to talk about here is geared towards those three states, primarily New Jersey, but also Pennsylvania and New York. We're also going to talk about federal estate taxes. So if you're listening to this seminar and you're outside of those three jurisdictions, then it's important that you speak with local counsel to see what taxes may affect your individual estate. Okay, so at the federal level, in 2025, the unified federal exemption has been increased to $13.9 million. It was $13.6 million in 2024. So for many, many people, their assets are comfortably under this federal exemption amount. Please keep in mind that the federal exemption is going to sunset at the end of 2025, and everybody's hopeful that we'll get new legislation between now and the end of the year, but we'll have to wait and see. And if there is no legislation that's passed, then it's likely that the federal exemption is going to roll back to New York has been keeping its basic exclusion amount under the old system. So going back to the federal level, if that $13.9 million exemption sunsets, you're probably going to see somewhere around where the New York basic exclusion amount is, and that's the very next line. So this year, that's $7.1 million. So again, if we don't get new legislation, the federal exemption is going to be halved. All right, and for many people now the conversation is a lot more interesting because you're dealing with a $7 million exemption than a $13 million exemption. These exemptions are per person. So if you have a married couple, each of the spouses gets the full 13.9 million. So for a married couple, you're really looking at pretty close to $28 million. Again, if you survive past the end of the year, who knows what's coming. Not entirely sure. So your estate planning documents have to be flexible to deal with it. For New York residents, we're going to talk about some of the implications for being over the $7.16 million basic exclusion amount, which is the second line on this slide. We'll talk about that a few slides from now. For those of you that are interested in gifting during lifetime, and I think this is an important thing to keep in mind, please note you can do annual exclusion gifts. That has gone up slightly in 2025 to $19,000 per person per year. And then if you have a non-citizen spouse, note that you can only gift the non-citizen spouse in 2025 up to $190,000 a year. Not an issue 90% of the time, but for example, if you were to buy a house that was worth $500,000, and then you put a non-citizen spouse on the house, that's gift is in excess of the $190,000 exemption. So something you need to keep in mind, for those individual circumstances. All right. So we just talked about at the federal level, if your estate, continues, the estate tax exemption, continues at the higher level, roughly around $14 million, a lot of people think it's not going to be a big deal for me. Well, not so fast. And that's what this slide is designed to show you. So let's just suppose right now your assets are worth anywhere from like $1 to $2 million. And you're fairly young, right? So you're not going to be dipping into your savings. In fact, you may continue to save even more, in which case you're going to accumulate wealth even faster than what we're showing here on the slide. But let's just say you're static at around 2 million and you earn about a 7% annual rate of return on your assets, which I think is somewhat realistic. All right. So the rule of 72 is a way of showing you how fast your estate is going to double. All right. So if you divide a 7% rate of return into 72, that means your assets are going to double in about 10 and a quarter years. All right. So you can see down at the bottom of the slide here, if you have 2 million at the end of 10 and a quarter years, you're going to have 4 million. All right. Add another 10 and a quarter years onto that. Now all of a sudden you're going to have 8 million. And 30 years from now, which I think for many people is not unrealistic, your 2 million now all of a sudden is worth 16 million. And now you may be having an issue with the federal estate tax exemption. So what I'm trying to demonstrate here is for a lot of people, you may think you're well under the estate tax exemption, but you're not considering future appreciation. And if your assets continue to appreciate over your lifetime, if you're continuing to save money, all of a sudden you're going to find yourself over the federal exemption. So it's very important to keep those exemption amounts in mind. All right, particularly if you live in New York, you can see after 20 years here, you're going to be over the New York exemption amount. So it's very important to keep those all in mind. All right. So for folks that live in New Jersey and Pennsylvania, unfortunately, there is an inheritance tax. All right. New Jersey used to have an estate tax, but in 2018, they reduced the rates on the estate tax down to 0. It may come back, who knows? There's nothing currently pending, but please keep that in mind. New Jersey still has an inheritance tax, however, so although it got rid of the estate tax, there is still a New Jersey inheritance tax, which we're going to talk about here in a few slides. Pennsylvania also has an inheritance tax, and there's an important feature of the Pennsylvania inheritance tax that New Jersey doesn't have, and that is Pennsylvania applies its inheritance tax to children and grandchildren. And we're going to show you the rates here in a second. All right, so first, the New Jersey inheritance tax. That's unaffected by changes to the estate tax. So for starters, if you're planning on leaving all your assets to either a spouse, a child, or a grandchild, well, they're all considered to be Class A beneficiaries for purposes of the New Jersey inheritance tax. And those individuals are not subject to New Jersey inheritance taxes. Again, those are spouse, child, and grandchild. All right, you can also throw in a few others, like, for example, a stepchild or a great-grandchild. All Class A beneficiaries, all exempt from the tax. There is no Class B beneficiary, so that's not a typo on the slide. However, there are C and D beneficiaries, which we're going to talk about in a second. And please also keep in mind that New Jersey applies the inheritance tax to all transfers that are made within 3 years of death. So if you're trying to do those annual exclusion gifts that we talked about a few slides ago, then they're all going to be subject to tax. All right, so C beneficiaries, who are these? These are brothers, sisters, they're a son-in-law or daughter-in-law, and that actually comes up a fair amount. I wouldn't say it's, typical, as in everybody does it, but there's a fair amount. Clients will come in, they'll say, hey, I want to include a son or daughter-in-law on my estate plan. Well, okay, if you live in New Jersey, guess what? They're going to be Class C beneficiaries, and here are the tax rates that are applicable to them. Same thing with brother and sister. So you get a whole $25,000, right? We all know that's not very much. So if you leave up the $25,000 to brother, sister, or a son or daughter-in-law, the first 25 will be exempt. The next 1,075,000, so everything else up to 1.1 million is taxed at 11%. All right, which doesn't sound like much until you start running through the numbers. All right, so at the full 1.1 million, you're talking at a tax in excess of $100,000. Right, it's a lot of money, 6 figures. All right, and you can see the rates go up incrementally from there, depending on how much you leave the C beneficiaries. Everybody else in New Jersey is a Class D beneficiary. So again, who are we talking about there? Nieces, nephews, cousins, distant relatives, your friends. All right, if you leave any of these people more than $500, they're going to pay 15% to the state of New Jersey. All right, and if you leave them more than $700,000, the rate goes up slightly to 16%. Again, it doesn't sound like much until you start running the numbers. So for example, I've seen situations where a D beneficiary winds up as the beneficiary of an individual's IRA account. Let's just suppose the IRA account's worth $1 million and it's left to a D beneficiary. Well, that individual is going to pay, 15%, 16% tax, depending on, the overall value of the IRA. All right, so you're talking at least $150,000 on that $1 million IRA. And where are they going to get the money from? They're going to go in and take it out of the IRA, right? Which there's no problem with doing that. There's nothing wrong with that per se. But a lot of IRAs are traditional, which means they're pre-tax. So as soon as you remove the $150,000 to pay the New Jersey inheritance tax, well, guess what? You've now incurred $150,000 in income. So now you're going to owe state and federal income taxes on the $150,000 that you removed from the IRA to pay the inheritance tax. So now you're getting taxes on top of taxes. So you can see these start adding up very quickly, and they can take a significant bite out of the assets. So it's important to keep these in mind. All right. Talking about the annual exclusion gifts. This is the $19,000 per person per year. This is a handy estate planning device that everybody should at least be aware of and consider. And again, you don't have to give the full $19,000. You can do less. Conversely, if you're a spouse couple, right, you can double the $19,000 to $38,000 per year. And again, you don't use up any of your exemptions. So this slide here shows you just the cumulative totals from just giving the $19,000 every year over 10 years. And as you can see at the bottom of the slide, you can move out a pretty significant amount of money. This doesn't even account for increases in the value, right? So let's just say you transferred the $19,000 out and your beneficiary invests the money, and now all of a sudden, the 19's worth a lot more after 10 years. And we had showed you on the previous slide, possibly even doubling the money, within that time frame. So again, let's underscore that this is a fairly powerful estate planning tool that you can utilize to move money to children and grandchildren. And again, you don't have to pay an estate planning attorney to make these. Probably be a good idea to speak with your CPA about it. So you'll incur some charges there, but I think it's very economic compared to the amounts of money you see on the screen here that you can transfer to children and grandchildren. All right. Not to leave out our PA and New York listeners. PA does have an inheritance tax. It affects all beneficiaries except for a spouse, as we mentioned before. Lineal descendants pay at a rate of 4.5%. Siblings, 12%. Everybody else, 15%. So it's fairly similar to New Jersey's inheritance tax, except for there is a 4.5% PA inheritance tax on children and grandchildren. And there's also a 1-year look back period on gifts. So those are included in the gross estate as well. And finally, if you live in New York does have a basic exclusion amount on its estate tax of $7.16 million. So the basic exclusion amount applies to your gross estate, right? That's all your assets, not just probate. So it's all your assets, life insurance, and some other things that all get included in the gross estate, plus gifts. All right, New York includes gifts within 3 years of the date of death. And this can include gifts that are not even included on the gross estate. There are some exceptions and exclusions that are unique to this tax. There are too many to go into for purposes of today, but there are a few, which I admit. All right. New York's estate tax has a top rate of 16%. All right. So again, it's not insignificant. These taxes start adding up if you start including them with income taxes and others. Another important feature for the New York estate tax is that you lose 20% of your exemption for every 1% you go over. So if you're only 1% of the way over the basic exclusion amount, you're going to lose 20% of the overall exclusion. All right. So after going over by only 5%, then you've lost the entire basic exclusion amount. So if you're wondering how much that is, that means for every 1% over, so that's $71,600 over the exclusion amount, you're going to lose 20% of the exclusion. All right. And again, if you're only 5% over 7.16 million, then there's effectively no exclusion at all. And it's entirely lost. All right. So that's an important feature for the New York estate tax. The other issue is that there's no portability. So at the federal level, conversely, if you don't use your $13.9 million exemption to transfer assets to children and grandchildren, you can just assign it over to the surviving spouse, and they have it for the estate tax or gift tax. Again, subject to some limitations. In New York, you can't do that, right? So if you don't leave or utilize the basic exclusion amount to leave assets to children or grandchildren, then it's gone. And then you're left with just the surviving spouse's basic exclusion amount. So it's an important issue to keep in mind. All right. What are some major non-tax issues in estate planning? So we've been through all these estate taxes. What are some really important non-tax issues that I hear all the time in my discussions with my clients? And I'll preface this with the following. So these non-tax issues can be really important. You know, everybody focuses on, oh, I'm going to avoid the estate tax or the New Jersey inheritance tax, not realizing that, you know, if they set their estate up in a certain way and they have a beneficiary that can't handle the money for whatever reason, you know, the losses that are caused by the beneficiary will dwarf the amount of taxes that they're on a estate. So these non-tax issues are very, very important. And in my opinion, they're almost more important than the estate or inheritance taxes themselves. So what's the first one? The first important non-tax issue in estate planning is what happens if your beneficiary dies. All right, so what do we mean by that? Well, here on the slide, you have a decedent, and they've left an inheritance to the beneficiary. So 75% of the time, that means a parent who's leaving assets to one of the kids. All right. And then what happens when the child who inherits the money dies? All right. Well, typically they leave their entire inheritance to their surviving spouse. All right. Well, if you're the parent, you may or may not like the child's spouse. And I can tell you quite frequently, the answer may not be, may not, right? So it's an important issue to keep in mind, because if you just leave your assets outright to a child, what are most of the kids going to do with it? They're going to put them in the joint account, right? And as soon as the assets go into a joint account with the child's spouse, they've now likely to pass to the spouse if that person survives. All right. So on the example here, this has actually happened a few times, right? The decedent dies, they leave their inheritance to a child. The child, unfortunately, doesn't survive very long, and then they die. They leave their assets to their spouse, and then maybe the spouse is young and they get remarried, right? So now all of a sudden there's a whole new spouse that's in the picture, and the grandchildren's inheritance may now be in jeopardy. All right, so this is an important issue to consider as part of your estate plan. Another important one, and unfortunately one that I'm seeing more and more and more of, is where you have a beneficiary that receives an inheritance, and they may have a variety of issues. All right, so they may have a dependency issue in drugs or alcohol, or, in some of the less intense scenarios, they just may not be able to manage money very well. It's kind of surprising sometimes. You see folks that really just can't manage money, right? There's a lot of assets sitting right there. All they have to do is a few items to transfer it into their name with the financial institution. For whatever reason, they just can't get it done. all right? Or the beneficiary goes ahead and does the transfer and then withdraws all the money. And then it gets burned up on credit cards, vacations, gift to the friends, or who knows where the money goes. All right. So these, again, are some very important issues to keep in mind if they affect your family. Because if you just leave the money to your beneficiary, you may or may not be doing them a favor, right? Especially if they have some of these issues that we just outlined on the previous slide. Okay, so what are some estate planning options that could be utilized to deal with some of the issues that we just talked about? So those issues, again, just to summarize, are the taxes that we talked about, and those are state and federal. Those are a child getting remarried or dying or going through a divorce, or your beneficiaries just simply not being able to handle the money for whatever reason. So an important estate planning option to deal with these is to create a trust, right? You don't have to leave the money outright to your beneficiaries. You can create a trust for them. As an example on the screen, you have a parent who dies. They may have a revocable trust during lifetime that then splits in half for the two kids. All right, and then you have a sub-trust for each of the two kids. Okay, and rather than leaving the assets outright to the kids. And the nice part about it you see right here is if something happens to one of the children, the trust can just pass down to the next generation, to the grandchildren. All right. And then this blows up one of these sub-trusts and shows you some examples. These don't have to be structured this way. They can be structured however you want. But these are just some examples, hypothetically, of how one of these sub-trusts might look. All right, so here I have sub-trust for child number one, and let's just say that child has two children of their own. So now there's grandchildren. All right. So the sub-trust can make income distributions to the child as well as principal distributions. And depending how you want things, the sub-trust can also be utilized to make discretionary distributions to the grandchildren, even while the child's alive. All right. And again, these can be structured in a number of different ways. So that would allow for part of the trust to be set aside for, let's just say, for example, the grandchildren's education. They're going to go to college. They need money for college. Maybe the child's struggling to pay for it. Well, guess what? You can take the money out of the sub-trust. Perfectly common and appropriate way to leave money for grandchildren to pay for college. And then you can utilize this from the sub-trust. If the child has issues, there's a divorce or there is a dependency issue, that sub-trust can be restructured so as to make discretionary distributions to the child. And if necessary, we can put on a trustee who's either another family member who's willing to do this or a professional trustee, such as a corporate trustee. And either the corporate or the family member trustee can be in charge of making distributions to the child, or if the child has an extreme asset management issue, then the trust can make distributions to pay directly for housing, for example, education, health, and so forth. All right, so there's a number of ways these trusts can be structured, and they can be utilized to assist the child rather than leaving the assets outright to the child, which may or may not be helpful. All right, so in conclusion, everyone out there should have an estate plan. As we talked about in the beginning, everybody needs to have at least three basic documents. That's a healthcare power, a power of attorney, and a will. If your assets are more sophisticated, you should add to that list a revocable trust. And if you're over the federal exemptions, then you should be looking into more sophisticated estate planning techniques, which were outside the scope of this presentation. We talked about the federal estate tax. Again, that's unified this year at 13.9 million. All right, with the gift tax. Please keep in mind there is a sunset at the end of 2025, and we're going to have some legislation probably this year. If we don't have the legislation, then the exemption is going to be cut in half. All right. We also talked about New Jersey, Pennsylvania, and New York estate, gift, and inheritance taxes, which can be addressed depending on your circumstances. If you have children or grandchildren, for example, in New Jersey. And if not, you should be at least aware of them and how they may affect your estate. in my opinion, addressing those taxes is important, but we also need to consider the major non-tax related issues in estate planning. And these can often be more expensive and result in more losses than the taxes can. So these are very, very important aspect of the plan. Frankly, in my opinion, they're the most important part. And if you have any questions on any of these, including the trust planning opportunities that we ran through, my direct number is 609-945-7617. And please feel free to call or email me. Thanks again for joining me today. And I do encourage you to reach out with any questions.